Um, I am I'm very grateful to our panelists first for your flexibility to move this event online. It reminds me the horrible time of the pandemic when we organized everything online. But as I was saying to the students, Mother Nature is something more powerful than AI, neurotechnologies, the metaverse, and everything. So we cannot stop the storm, and we cannot stop the decision of the university that took yesterday around 6 p.m. So we wanted to maintain this event. Uh, we wanted to maintain this event, as I'm saying, at least online, because all the great panelists agree to speak about uh, neurotechnologies and the challenges on neurotechnologies. So thank you very much. I think that more people are going to start joining us soon, but I want to stick to our time in the agenda. I would like to pass to Carson Morgan from the Technology, Security, and Society, who is a co-host of this event. All the students worked too hard during this year to have this event. So I want to say thank you to all the team and the students that make this event possible as well. So then I'm going to moderate the panels, but we are going to say something else. So for the record, Carson, this is your turn.
Thank you, Professor. Good morning, and thank you all for making the time to be here today. My name is Carson Morgan, and I'm president of the student-run organization Tech Law and Security Society here at WCL. I'm so pleased to have been approached by the Center for Human Rights and Humanitarian Law to host the symposium and discuss the human rights and privacy implications of emerging neurotechnologies. While these technologies promise major advances in healthcare, they also raise critical concerns about privacy and autonomy. Conversations like these are essential as technology continues to move faster than law and policy. I hope today's discussions catalyze thoughtful dialogue and practical ideas for protecting human rights in the digital age. Thank you, and I'll now hand it over to Jordan.
Sorry, there we go. Thank you all. And good morning. My name is Jordan Bellamy, and I'm a 3L part-time evening student here at WCL and one of the Dean's Fellows with the Center for Human Rights and Humanitarian Law. And it's my honor to introduce our moderator, Professor Eduardo Bertoni, Director of the Center for Human Rights and Humanitarian Law. Professor Bertoni has many accolades, as I'm sure if you guys know. But just to name a few, he is an Argentinian lawyer with a master's degree from the Elliott School of International Affairs at the other school, George Washington University. He is the founder and director of the Center for Studies on Freedom of Expression and Access to Information at Palermo University School of Law in Argentina. And he served as special reporter for freedom of expression at the Inter-American Commission on Human Rights and as the first director of Argentina's Data Protection and Access to Information Authority. Most recently, earlier this month, Dr. Bertoni spoke at Congreso Futuro 2026 in Chile, one of Latin America's leading public forums on science, innovation, and the future of society. His work has truly taken him all over the world, most recently Antarctica. So despite the winter storm that's kept us all indoors today, this weather is probably practically like the beach conditions for him. So if you all would please join me in welcoming Professor Bertoni.
Thank you very much, Jordan, for this introduction. So it's time to work. So let's start with the first panel. But let me tell you something about the origin of this event. The Center for Human Rights and Humanitarian Law is an old center. We work for students and with students on opportunities related to do more things on human rights and humanitarian law. 2 years ago, we started some sort of informal program on technology and human rights. Some people may remember that we organized at that time many conversations like this. One of the conversation we started to talk about neurotechnologies. At that time, we also talk about the metaverse, we talk about artificial intelligence, and many other things. So we decided to continue our program on technology and human rights, and we decided last year in 2025 to organize this event on that we put a very ambitious title, which is Neurotech on Trial: Hacking for Healing and Guarding Privacy. And I will want to stick on this idea of guarding privacy because one of the current discussions in the realm of neurotechnologies is the discussion about what are the neuro rights, what people call neuro rights. Sometimes he's going to talk about that for sure during this meeting, but many scholars, including me and many others, include the idea of neuro rights of personal data or data rights, okay? So that is the reason why we decided to organize this event on January 28th, because January 28th is the Data Protection Day, and it's the Data Protection Day because it's celebrating the enacted of the Convention 108 of the Council of Europe, which is the only treaty that protects personal data internationally. So we decided to celebrate the Data Protection Day talking about neurotechnologies, thinking that neurotechnologies has a lot to do with privacy, has a lot to do with personal data, and that's the reason why we organize this event on January 28th. We didn't expect a storm. We didn't expect that the university is going to be closed. So the expectation was to have an event here in our beautiful law school, have lunch, have conversations, formal conversations, informal conversation, but that's life. So we move this event virtually, and we want to have this event for the future and to continue this conversation with all the great experts that agree to be part of this meeting. So even though we are not going to have the audience that we expected if we have this event in person, I am sure that people will enjoy and will learn a lot from our experts when they have the chance to look at the event that is going to be published soon in our YouTube channel. So, having said that, let's start with our first panel. And our first panel, we changed a little bit the original agenda that we envisioned for the original meeting, but the first panel is going to talk about different things under the title of Interdisciplinary Approaches Toward Emerging Technologies. So each of the panelists will have approximately 15 minutes to put their ideas on the table. If we have time, we can have a brief discussion among the panelists. If not, we are going to move forward because we have limited time also, and we don't want to have a very long virtual event because it's exhausted. we experienced that during the pandemic, so we prefer to have and concentrate with the main thoughts of the panelists. For this first panel, we will have Jennifer Jean. I'm going to introduce each of them: Alex Joel, Koy Miller, Diego Borbón, and Brittan Heller. I'm not sure if everybody is here yet. If not, we are going to start with Jennifer. I'm very happy to have Jennifer in the panel. Jennifer, I'm not going to read all the bio of this great group of people, but let me say only that Jennifer is an artificial intelligence and data policy analyst at the Center for Information Policy Leadership, which is CIPL, I have been working with CIPL for many years. We are partners in many projects, so I'm very happy to have Jennifer with us today. Then I will pass the floor to the next one, who is my colleague at AU, Alex Joel. Alex do not need any introduction. He is the Senior Project Director and Resident Adjunct Professor at our Washington College of Law at American University, and he leads the Privacy Across Borders initiative. He's a real expert, worldwide known about privacy. He has been working within the US government as well, if I am correct. So I'm very, very happy to have you, Alex, here. We can have coffee and here at the law school at any time. In We are going to have in this panel also Professor Diego Borbón. Professor Borbón is a very young professor from Colombia, but he has a very long experience working on neurotechnologies. He is at the Center for Studies on Genetics and Law and the director of the research group in biological science and law at the University Externado in Colombia. I would like also to introduce Brittan Heller. Brittan is, well, Brittan do not need introduction. Everybody knows Brittan Heller, but she is a teaching fellow for the program of Law, Science, and Technology at Stanford Law School. She has been reading a lot about technology, artificial intelligence, the intersection with rights. I learned a lot from you, Brittan, and I'm very happy that you accepted to be here. And I'm very sad that we are not going to have the opportunity to have lunch or dinner together today. But I'm sure that we will have any other opportunity, probably in Stanford next time. And last but not least, I'm not sure if Koy is also in the.
I'm here.
Yeah, Koy. Oh, thank you, Koy. I didn't see you. Thank you very much, Koy. We really want to have someone coming from the private sector. We have you and we have David. I'm going to introduce David in the next panel. Koy is a policy professional at Meta Reality Labs organization based in Washington, D.C. And her work centers on shaping policy strategy for emerging technologies, including immersive and other wearables technologies, artificial intelligence, and network infrastructure. I can say much more about Koy. She also worked for the US government in the past, if I am correct. So she has a lot of experience. This is a great panel. So if you can, 15 minutes, your thoughts about some of the questions that I put on the agenda for us, but you can talk about this idea of the interdisciplinary approach towards emerging technologies, privacy, and these kind of things. So we will go in that order: Jennifer, Alex, Koy, Diego, and Brittan. So Jen, the floor is yours. Please, 15 minutes. I don't want to start screaming online. Thank you.
I'll be very mindful of time. Well, thank you so much for hosting this incredible event, and to all my panelists. Very sad that we weren't able to meet in person, but glad that we can still meet virtually on this platform. Just to give a little bit of a background about CIPL, Center for Information Policy Leadership, we're a global privacy and data policy think tank based out of Washington, D.C., Brussels, and London. And we often work with industry, regulatory authorities, and policymakers to develop global solutions and best practices for privacy and just holistic and responsible use of data in this increasingly digital world. It's always interesting to come back to neurotech and neuroethics because that's where I started out. I do a lot of work on AI and data privacy now, but I started in neurotech and neuroethics, so it kind of feels like I'm going back to my roots. It's interesting because when I first started out at CIPL 3 years ago, we were having conversations about neurodata and neuroethics and neurotech then. Fast forward a little over 3 years from now, we're still having those conversations because a lot of those thorny issues haven't really been resolved yet. We all know that neurodata is an emerging frontier in data protection, and I'll be speaking mostly from that lens since that's what I primarily do at SIPL. And we're obviously in a very gray zone with regulation, and while many existing laws tangentially cover neurodata, they don't fully safeguard, the ideas of mental privacy or autonomy. There's a few jurisdictions that we know have called out neurodata specifically. For example, Chile became the first country to include neural rights in its constitution. California amended its law to add neural data to the list of sensitive data elements, and Colorado passed a law to provide consumer privacy protections for neural data. So we're seeing movement in the regulatory space, and policymakers are acknowledging the importance of protecting neural data and awarding it similar protections. And of course, though current data protection requirements will apply to any personal data collected from Neurotech, there's still an open question of how data protection laws will practically apply to neural data and if current data protection rights are sufficient to protect against potential risks and harms, or if new rights are needed to be created. Overall, regulations and organizations need to consider how the current laws should be interpreted or adapted to cover the unique aspects of neurotech. And under current laws, we know that neurodata may be considered personal data, but it may also be considered biometric or sensitive personal data, which of course will trigger heightened safeguards under existing laws. In the absence of clear understanding of how existing laws apply, or if new guidance or laws are needed, organizational accountability can step in and serve as a guiding framework for how organizations can responsibly build neurotech. SIPL has long promoted this idea of organizational accountability as a key building block of effective privacy and data protection regulation and compliance. And a well-developed, comprehensive accountability framework or program provides organizations with the tools and processes needed to implement relevant legal requirements and standards, as well as internal ethics, standards, principles, and other internal best practice goals. SIPL's accountability framework, you might have seen like our wheel, outlines 7 core elements of accountability, which includes leadership and oversight, risk assessment, policies and procedures, transparency, training and awareness, monitoring and verification, and response and enforcement. Our previous work has demonstrated that global businesses can use it as a model for building both comprehensive privacy and data programs, but also AI governance programs, and is equally fitting to serve as a framework for emerging tech like neurotech. We know that in the absence of clear regulations and this patchwork, as we always say, robust data governance and privacy programs can be a key differentiator in how companies choose to demonstrate responsibility. An April 2024 study showed that many neurotech companies failed to disclose how user data is handled, even though they operate in jurisdictions with comprehensive data protection laws that require things like disclosure and notice. This lack of transparency can undermine both consumer trust and also compliance with existing laws. And as tech inevitably pushes the boundaries of what is possible, adoption and scaling will require human trust, and organizational accountability can help drive that. Because there is an onus on companies to get this right. Trust is not just a social imperative, but also a business enabler. Greater trust means a greater willingness to adopt the technology, which is overall good for business. Accountability steps beyond just compliance. It's more than just a checkbox of, okay, what have we done to meet just the basics of the law? It's proactive governance, and embedding accountability can help bridge gaps where policy is still developing and ambiguous. This is an area that SIPL believes that established organizations can and should lead by example. This can look like embedding privacy, security, and ethical safeguards into product, service, and design and deployment. It can look like deploying pets where appropriate to further safeguard user data and reduce the risk of re-identification. And you can even embed responsible governance practices as requirements in contractual agreements to incentivize or even require partners to level up. So how can the rest of stakeholders support responsible development and deployment from organizations? Well, first, guidance and clarity from regulators is always helpful. Rather than rigid definitions or requirements, regulators can be encouraged to take a risk-based approach that focuses on actual use cases and applications of the technology and also tangible harms. Too narrow or broad definitions can lead to regulatory uncertainty and become quickly outpaced by rapid development of the tech and even stifle potentially beneficial uses of the technology. Harmonized standards can also help reduce fragmentation across jurisdiction, again, pointing back to that patchwork of laws that we're currently grappling with AI. We saw the impacts of this before with privacy, and as I mentioned, we're seeing it again with AI. Fragmentation makes it really difficult for companies to comply and understand how laws and requirements can apply to them. This is especially important to consider with neurotech because a lot of where the consumer-facing innovation is happening beyond the medical application is happening at the startup level, which already struggles with resource constraints. Collaboration and open dialogue between stakeholders is also really critical. So having environments and platforms like these where we can all come together from different sectors to discuss these issues is really, really important. Government, society, civil society, industry, and multilateral institutions can all play a role in working together to shape the future governance of neurodata. And neurodata also touches on a lot of different principles like mental integrity, cognitive liberty, autonomy. A lot of these principles are layered with cultural nuance and influence about how we consider the mind, the body, the soul, how we view the use of data for collective good versus the role of individual rights. Again, it's incredibly nuanced, and we have to be mindful and respectful and aware of that as we navigate these waters. And standard development and international cooperation can help provide additional clarity. Of course, there's a lot of current relevant regulatory considerations and how they impact neurotechnology on wearables, and especially with the increase in people wearing wearables and the new focus on wearables generally. But as we continue to navigate these things, it's great that we have platforms like these so we can all talk about them together. So I will cede 6 minutes of my time. Professor Bertoni, thank you so much for inviting me again, and looking forward to the rest of my panelists as well.
Oh, thank you. Thank you very much, Jennifer. Very interesting. I highlight these ideas about the importance of collaboration in some sort of multi-stakeholder, conversations when we are talking about technologies, and particularly on these emergent technologies. So I'm really happy to hear about that. So the next, if I am correct, is you, Alex, right? Can you move on?
Yes, I can. Thank you so much for having us, and I applaud your flexibility and speed with which we have moved this event online. So that's terrific, and it reminds me of the flexibility and speed with which tech is moving. And as you pointed out with the pandemic just 6 years ago, well, we would not have had this platform and the ability to quickly pivot at a moment's notice to now have the event online. So it's amazing how quickly technology changes and how quickly we adapt to those changes, which brings us to the topic of neurotech. And as people who know me know, I like to use an analogy when thinking about tech in general and how quickly it changes that helps me think about the implications. And for neurotech, and that analogy is the black box, right? So the new tech is this box, and magic is happening inside the box. And for that magic to happen, you need data to feed into it, and then it produces outputs that have impact in the real world. So I see this flowing of data into the box. Something magical happens inside the box that we have to try to understand as non-techies, and then the results flow out and have real world impacts. And I think for neurotech, that analogy is I was thinking about this leading up to the panel and made me realize that the boundaries of that box are permeable, like where it's now interfacing with our brain and reading the electrical activity in our brains. And so there is this sort of the magic happening in the box is a mixture between the computer processing that's taking place as well as the our own neural processes. So I think it's unique in that sense. The data that it's processing is very intimate personal data in terms of our own brain waves and what it can read from that. And the impact on the outside world is variable. So it depends on the kind of tech and the uses that it's being put to which it's being put. So if I focus on thinking about that analogy, we then look at the box itself. And to me, and I'm not a deep expert in neurotech, so I'm looking at this from a more broad perspective. So I sort of categorize these things into two broad types of tech that cause different issues, that create different issues in my mind. One is the invasive surgically implanted tech that that enables people to have a brain-computer interface so that they can have more ability to maneuver themselves through the outside world. I view this invasive kind of surgically implanted tech as being, at least right now, being thought of as is placed in the medical context, which is reassuring, right? Because you then bring in the whole regulatory framework, the difficulty of implantation, the need for updates, all that's getting easier and easier, I understand. But we have an ethical system and a regulatory system for thinking about technology that is medical in nature, that has a medical purpose, and that requires medical professionals. So it's very invasive in that it can do a lot of things. It can have a major impact on the world, but it's confined to an individual, and it's specifically it's within this box of the medical community. There are uncertainties in terms of the data that is collected. So I think there we have some issues in terms of what is that data and how can that data be shared and used for other purposes. So I think that still needs to be addressed as a data protection issue. And then, from the invasive side, we go to the non-invasive side, as Jennifer was pointing out, the wearables, which are much more common, much less invasive, much easier to use. They also have, less functionality. They're not going to have the kind of dramatic breakthroughs that invasive neurotech will have. But they're going to be much more widespread. And so to me, the issue really breaks down into when you look at the narrow, invasive, deep impact versus the much broader consumer wearable issue, I think they present different kinds of issues that require different sorts of legal and policy responses. I am, at the moment, and I can be persuaded otherwise, less concerned about that invasive tech, even though there are efforts to, find ways to use it in different ways beyond the medical context, and more concerned about the wearables and the kind of data that is being collected and shared. So if you look at, and there have been studies done about this, it's particularly in the United States, when you look at how we regulate data that companies collect about their customers. We have a sectoral approach, as I was talking to my students just last night, in the United States. So you have to fit within one of those sectors. We also have state privacy laws, which other people will talk about, that also come into play. And then we have the FTC Act, which requires companies to post accurate notices of how they're collecting and using personal data. And it cedes to those companies a significant amount of discretion in terms of how they want to use the data, so long as they're being upfront and transparent and they're posting those notices. And so the data that's collected from the wearables is something that could be of significant value in the aggregate as well as individualized. I'm less concerned about the individual use for targeting a particular individual, although I'm going to get to that in a second. There is a concern there. But I do wonder about the aggregate of the data and what it tells us about how people react to certain kinds of stimuli. Can we better predict whether or not a person will be suspicious or fearful or distrustful or trusting in response to various kinds of information that person is consuming? And that matters a lot these days. I'm going to pivot now to a national security set of implications here. one of the things that we're seeing happening geopolitically and in the United States and other countries around the world are narratives that get propagated about people's beliefs and trying to perhaps manipulate or influence opinion, trying to create dissension, trying to create disagreement, trying to create confusion in other countries. It's in the playbook of certain national security organizations from different countries around the world to do this, to find ways to weaken the resolve of a democracy, to create confusion, dissension, to separate allies from each other so that the particular country that has adversarial designs, expansionist plans, et cetera, is better able to act on the world stage without fear of a unified response that has popular support. Countries are already leveraging data in order to carry out these information campaigns, right? So there's a lot of data out there, a lot of personal data that allows experts to, including companies, but certainly governments as well, to draw inferences from human behavior, from the technological data streams that we all create as we use our devices on a day-to-day basis. And so to some degree, neural data can be thought of as an enhancement of those existing sources of data. It is a way of adding additional, of enriching that data. It standing alone is certainly could be very valuable, but then when you add it into all of the other data sources, it could become, a game changer. I don't know. I haven't done enough research on this, but I suspect that this is something that could be extremely valuable if you're looking at how do you better understand and perhaps influence reactions of a population on a larger scale when you have access to large amounts of neural data. I don't see that happening right now. I don't think the situation has become advanced enough, but I think that's an implication. And we see in the United States has already taken measures to protect sensitive data from flowing to what we call countries of concern, primarily China and Russia, but also Iran, North Korea, and perhaps also Venezuela and Cuba were the countries that have been identified in various legal instruments coming out of the United States to prevent the flow of sensitive data to adversarial countries where that data could be exploited to undermine U.S. national security interests. And one of those ways in which that could happen is through disinformation campaigns. Cognitive warfare is the term that sometimes the military community uses to describe this. So I do think we have to pay close attention to neural data in that sense. I think it can. I said earlier that it's I'm more interested in the implications of the broad amount of data that and the way it could enhance existing data sets that are available for this purpose. I think more narrowly, the concern with sensitive data going into adversarial hands for any bad actor, but from my background is in national security, from a national security background perspective specifically, is that it would enable more precise targeting of an individual. Like if you wanted to get an individual to either betray their country, or give you access to information, or maybe trust you and give you their login credentials as an example, like more effective and targeted phishing campaigns, I would imagine that the neural data for that individual, an individual who is in a position to help people access critical infrastructure, for example, who might be susceptible to certain kinds of approaches, I think neural data would be an interesting, again, additional component for an adversary to learn about. So I think there are a lot of significant risks that we have to think about, not only for personal privacy and autonomy, but also for these national security implications. I will say, if you now switch just briefly to the legal aspects and the legal framework, very interesting questions that I think are still being discussed. Once these companies have this neural data, either because of an invasive implant or because of a wearable, how can that data be accessed by a government, right? So obviously, governments engage in espionage, so it might be stolen. To the extent that, are there controls on companies selling that data, making it available to third parties, making it available to data brokers, right? So there have been movement in the United States Congress to regulate data brokers, and we see, with data broker transactions to China, for example, have been regulated. But in general, we still rely on the sectoral approach in the FTC Act. We don't have a comprehensive privacy law. Different states are stepping in and are helping regulate that flow of data. So, the government, governments around the world, how do they get this data? A, steal it. B, buy it. C, acquire a company that's engaged in this business. And that's where we get into, in the US, CFIUS and the Committee on Foreign Investments in the United States, which looks at the national security implications of foreign ownership, like TikTok and ByteDance. Or D, demand it, compel it. How do you compel the production of that data? And I think the compulsory authorities, I would guess, and the protections that are put in place against those compulsory authorities were done at a time when Neurotech was not within the imagination of people. I do think it presents very serious Fourth Amendment concerns, in terms of, is this a search or seizure? Do you need probable cause for it? And I think that there's a strong argument on both sides on this issue, because on the one hand, it's deeply personal information. On the other hand, it's in the hands of third parties. And so in the United States, we have the third party doctrine. So there's a strong tension there that's not been resolved, to my knowledge, by the courts as it applies to Neurotech. I think I would weigh more on the side of the Fourth Amendment applying to this, especially because of the First Amendment implications of understanding what somebody is thinking and feeling. I'll just close with a quote. Having said that these developments could not have been predicted, Justice Brandeis always surprises me when I reread his famous dissent to the Olmsted Supreme Court case in 1928. And he wrote at that time, "Discovery and invention have made it possible for the government, by means far more effective than stretching upon the rack, to obtain disclosure in court of what is whispered in the closet. Ways may someday be developed by which the government, without removing papers from secret drawers, can reproduce them in court, and by which it will be enabled to expose to a jury the most intimate occurrences of the home." So far, I've always thought of that part of the quote as referring to cloud computing and things like that. And then he says, "Advances in the psychic and related sciences may bring means of exploring unexpressed beliefs, thoughts, and emotions." And I think that's the key risk with neural data. These are unexpressed thoughts and emotions that we're having that are reflected in how our brain is emitting these electrical signals. And how do we think of the Fourth Amendment? How do we think of privacy protections when technology has allowed us to actually try to estimate or analyze or assess what people are thinking and feeling? All right, thank you. I will look forward to hearing from others and learning.
Thanks a lot, Alex. It's great how you frame this conversation within the scope and the field of data protection. And it's very interesting to hear you from your perspective about protections in the US. We are going to hear more about protections outside the US during our conversations today, but it's very interesting to talk when we are talking about neurotechnologies and neurorights, how we link it to personal data. And the other thing that I really highlight on your conversation, you were more, because of your background and your studies, you were more concerned. I cannot say concerned, but concerned on the use of this technology for security purposes, how to, people can, or governments can use that for security, or even for judicial procedures and so on and so forth. But during our conversations, I would like also to hear someone talking about the good use of this kind of technologies, for example, in the health environment, okay? Because we have these things with neurotechnologies. Neurotechnology could be used in a way that we really don't want and impact negatively human rights or constitutional rights. You mentioned First Amendment, you mentioned Fourth Amendment, and I agree with that. But we can use neurotechnologies also for improving the health of a lot of people. So I'm sure that we are going to continue this conversation. But now I will pass the floor to Koy. Maybe Koy can tell us more about devices that the private sector are developing. Interesting that Alex make that division of invasive technologies and not invasive technologies. So that's great. So Koy, the floor is yours.
Thank you. Thank you so much for inviting me to join this panel. And I am looking forward to talking about some of the beneficial use cases that you mentioned. At Meta, we're working to build the future of human connection and the technologies that make that possible. So I appreciate the chance to be part of this conversation alongside the experts that you've brought together today. We have spent significant time collaborating with researchers, industry leaders, academics, and ethicists and practitioners across multiple fields, not only to advance the science, but to help ensure the technology is designed to work for a diverse range of users, including people with different motor abilities. As some of you may know, we've been researching EMG for about a decade because we believe it can meaningfully expand how people interact with devices and how they control their world. We're excited to be at a point where we can begin translating that work into real products and to do so in a way that's thoughtful and responsible and grounded in what users actually need. So I'll leave it to my colleague David, who's on the next panel, to discuss the current regulatory and legislative landscape, and I'll use my time to talk about how Meta is incorporating these emerging technologies into our products. So last year at Connect, we released the Meta Neural Band, which is a wrist wearable that uses surface electromyography, or SEMG. It combines a high-performance textile with embedded EMG sensors to detect the electrical signals generated by muscles at the wrist. An on-device machine learning processor then interprets those EMG signals to enable gesture-based controls of our display glasses and provide more advanced interaction capabilities. By combining EMG signal detection and machine learning, we can achieve seamless on-the-go experiences that allow users to communicate and interact while staying present in the world around them. We see the Meta Neural Band as the next generation of the keyboard or the mouse for users to interact with and control their devices throughout their day. EMG can only sense user outputs using electrical signals from muscle activations. It does not stimulate or write any information back to the body. Kind of talking about the non-invasive, this is kind of referencing the non-invasive discussion that we were just talking about with Alex. The technology senses muscle activations at the wrist and electrical signals that are generated by a user's hand gestures. These signals do not represent an individual's internal thoughts or cognition. Surface EMG at the wrist is therefore not a brain-computer interface like other technologies, and as a result, SEMG at the wrist is both physically and cognitively non-invasive. Users have complete control over when and how they want to move their hand to control their device, and the wristband senses only the signals driving the user's outward motor behavior, not the internal cognition from which the behavior arises. The Meta Neural Band ships alongside our AI display glasses, and it's designed to address a very practical user need, which is natural, low-friction control, especially in moments when pulling out a phone or using your voice or doing large hand gestures isn't ideal. With the neural band, subtle muscle activity at the wrist can be interpreted as a set of reliable inputs, enabling things like scrolling, clicking, and dial-like controls. At CES this year, we introduced a new feature for the neural band that we call neural handwriting. It builds on that same EMG foundation. The basic idea is simple. Instead of tapping or on a keyboard or speaking out loud, you can write with your index finger on almost any surface, whether it's a table, your leg, or even your other hand. And the system translates these subtle muscle patterns into text. It's intended for situations where people want to stay present and communicate quietly while still responding in their own words, not just generic quick replies. This experience also supports things like autocorrect and context-aware word phrase suggestions. We don't think of this as EMG for one device. We think of EMG as a future input platform, a way to control many kinds of interfaces where today's inputs don't always fit. That's also why at CES we announced a proof of concept with Garmin's unified cabin for automotive experiences. In that demo, Meta Neural Band is used to navigate an in-vehicle interface used for infotainment purposes, scrolling through options and selecting with a pinch, to illustrate how this kind of subtle risk-based input could enable safer, more accessible interaction in settings like a car where attention and ergonomics really matter. We'll continue to support research in this area through academia, through our partnerships with universities, and we'll help optimize EMG use cases for user benefit. Of course, protecting user privacy is at the core of everything that we do. Meta Neural Band is designed with privacy by design protections that focus on minimizing what data is collected, putting the user in control, and securing data transfer via encryption. First, we use data minimization on-device and on-device processing by default. For the core product experience like gesture-based controls, EMG sensor data is intended to remain on the device. That means we don't need to upload raw EMG data to make the device work. Second, we rely on user control and consent for any EMG sensor data sharing with Meta. The primary case where this data could leave the device is when a user initiates a debug or a bug report flow where they may have been having issues with the band. In that situation, we provide an in-app notice and consent before any EMG sensor data is shared with Meta, and that's for troubleshooting and product improvement. Finally, we have a strong security regime in transit and in storage. When EMG sensor data does move, such as between the neural band and our AI display glasses, communications are protected with encrypted channels, for example, encrypted Bluetooth links, to reduce the risk of interception. So again, thank you for inviting me to speak about Meta's work in this area. And I have to say, just like everyone else, we're really excited to see where the technology takes us. Now I'll turn it back to you.
Okay, I was trying to unmute myself. Thank you very much, Koy. Very interesting. I would like to mirror this conversation with what just Alex said, because it's important when we are framing neurotechnologies, and particularly what people call, and I say people call because I don't like the name, neurodata. When neurodata is personal data and when neurodata is not personal data. Koy, was saying a lot of things about some of, interventions, if I may say in that way, of the neural peripheral system, not the central system, that probably all the information coming from there is not personal data. So if it is not personal data, it's not going to be, bounded or controlled by any kind of personal data regulations. Here in the US, in Consumer Acts, in the Consumer Act in California, for example, or internationally in the Convention 108. We are working on something like that with my colleague Marcelo Yenka for the Council of Europe, but we can have more conversation about that. But I appreciate when you mention this kind of, differences between, some data that could be personal data and some data that has no information or have only user control, that you are not storing the data, and so on and so forth. We can go back to this conversation at the very end, but now I would like to pass the floor to my very young colleague Diego Borbón. Diego is moving all around the world talking about neurotechnologies. So, Diego, the floor is yours. We are seeing a presentation. I appreciate that you are here today. For the people and for the record, I called Diego yesterday and he was almost taking the plane coming to Washington, D.C.
I was in the gate.
Literally, he was in the gate. And it was at the same time that we received information from the university that the law school will be closed today. So I guess that Diego is in his country, Colombia, and we really want to hear you, Diego.
Thank you, Eduardo, and I apologize to everyone because I love slides. So I'll be attacking every one of you with my slides and a lot of information on academic discussions, but also on international regulatory perspectives. And I want to disclose that I have a big bias, and my bias is that I like to lead the country in everything. So I may be saying some controversial things. This is a book of our former Minister of Education, writes alguien tiene que llevar la contraria. Someone has to lead the country. So if I say something controversial, we can have, of course, a respectful discussion about it. That's what academia is for. So when we talk about new rights and new technology, we of course care about the ethical risks. Many papers have presented some of the interesting but also worrisome findings that new technology can't disclose or represent. For example, this paper was able to decode like internal speech and internal thoughts. Of course, one might worry about mind reading. This also decode, for example, what someone was seeing just by analyzing the functional activity of the brain. So we can see what you're seeing, but just looking at how your brain works. This other one represents optogenetics, which requires genetic modifications using viruses that make the neurons of this mice's brain photosensitive, so you can control the behavior. And in this case, they were able to induce predatory hunting behaviors against plastic thing. In DBS, which is deep brain stimulation, which is widely used in Parkinson's disease as a treatment for the symptoms, it has also shown changes in personality, changes in behavior, changes in emotions. So one can worry about identity and personality and psychological continuity. And also in criminal law, we worry about the use in neuroprediction, which is the intent of doing risk assessments to predict criminal behavior or in lie detection, or in which is being called moral enhancement, which is the idea that we can enhance antisocial behavior with the use of invasive stimulant neurotechnology. This is not necessarily an unproven worries. For example, in the US in 2015, there was used the biological information of Ross Compton was used against himself. The information of a peacemaker was used against him in a case of arson and insurance fraud. So we, of course, need to protect people, and we need to protect biological data and the rights of people. That's why my dear querido compañero y amigo Roberto and Marcello have proposed 4 neuro rights, which is also complemented by the proposal of Rafael Juste of the New Rights Foundation. And now they also were proposing 5 neuro-specific rights. The idea of these neuro rights, that a new list of human rights, is to add a new layer of protection to this from this technology. But just to do some brief things, like since 2020, we have been saying some critical aspects of why maybe some of these new rights, especially the ones promoted by the New Rights Foundation, and I know here we have another panel with a person from the New Rights Foundation, so this is very interesting. We have pointed out some conceptual problems on concepts such as free will, for example, as identity and other things. Free will is, of course, a very philosophical and complex problem that doesn't have any solution. So it's not advisable to create a right on that specific philosophical debate, and other concepts that also might just be reinterpretation or conceptualizations of other existing rights. Problems, ethical problems, maybe, for example, the debate on human enhancement. So the New Rights Foundation proposes a right to equal access to mental augmentation, which is basically to have a positive prestational right that people can access to technologies that do not have a purpose of public health or therapeutic applications. So that's also, at least in ethical terms, something we need to discuss in this debate of therapeutic versus nature, or versus therapeutic enhancement, or transhumanism versus human nature. Also financial problems. If you create a right to equal access to mental augmentation, that means that someone has to pay for it, and who pays for it? Of course, maybe the state. So we don't necessarily have to create a right for everything that we find problematic, because that also might mean that someone has to pay for it, which means the taxpayers have to pay for it. Do we need a new list of rights? Maybe not, because most international and national conventions and constitutions already protect freedom, consent, freedom of thought, privacy, information, physical and mental integrity, bodily integrity, equality, justice, and non-discrimination. Bowlitz, for example, has said that creating new list of rights might endanger them by inflating the list of rights, and also that the narrative behind most new rights initiatives is a little bit dangerous, because it's telling the public that our current human rights standards and current public international law is insufficient to address those challenges, which many don't think it's true, me including. Also, some worry about if there are relative or absolute protections in the proposal of Bianca and Andorno. It is very clear that these new rights are relative, so maybe the state can use new technologies against our rights in the name of public safety or general interests. And also, we already have even some more protective human rights of human dignity, which in many countries like Colombia and in many countries of Latin America is an absolute direct application human right. Or in Europe, freedom of thought is also an absolute right of direct application. So I'll make a very brief overview of what's happening in Latin America. In Latin America, we have now a mess. We have 29 initiatives of very different nature. In many countries, even 6 initiatives, like Argentina, in Mexico, in Brazil, in most of the countries. And if you want some of this information, we will send very soon a policy paper about it. But that's why I published a very brief commentary in Nature, saying that we have a problem of very fragmented neuro rights initiatives across Latin America that have many discrepancies, many conceptual problems, and that we don't really have a clear understanding of on what do we need to do. And a very clear example of it is the Latin American Parliament model law on neuro rights. If you don't know, Latin America has a parliament. No one really cares about it because it doesn't really work. But the Parlatino, which is the Latin American Parliament, created a model law on your rights. And it is a little bit complicated because it is really confusing much concepts, such as confusing identity with autonomy or creating many different concepts. For example, in the F right, it's prohibiting any intervention without the consciousness of a person, including medical circumstances. So if you have a car accident, for example, and you get to the emergency room, under this model law, you cannot be intervening in your favor, even in medical circumstances, if you're not awake and conscious. But also, when you look at the sources of information of these types of initiatives, you're going to see that they're based on Wikipedia, on other non-scientific sources of information, or even saying other various as a source of information, which is not really good. I put this in Turnitin, which is a plagiarism software, and it showed a 69% of similarity, which is not the same to say that it is plagiarism, but at least 69% of the model law is copy and paste from web sources and blogs of opinion. So that's not the best regulation we can do, maybe, I think, my opinion. That's why I published a paper called What a New Rights Legislation Should Not Look Like, the case of the Latin American Parliament. Other examples, more interesting ones, the case of Mexico. Now Mexico has a bill which is the most comprehensive bill and most ambitious one, which is 200 pages long because it creates 10 neuro rights and it reforms 35 different laws and also create 4 neuro crimes. So our friends from Mexico are maybe going to the next extreme, which is over-regulation of new technologies, even creating criminal law reforms. Maybe I think Gilbert and Russo are a little bit. I agree with them because they may say, well, new rights may be the land of speculative ethics and alarming claims. And now that's a narrative that's going on in Latin America where we really are very worried about many things. So maybe we are going on a rushed type of legislation, and we definitely need more things to do. Chile is the most famous country about it, but I have to say Chile has not made many things, in my respectful opinion. They just have one paragraph in the constitution that says that you have to protect the information from the brain, but nothing else. They ought to try to create a bill which didn't pass Congress, and other cases, Argentina, like this one, which creates a new law in criminal law that requires a court warrant and the consent of the person to be used in criminal proceedings or in correctional settings. I want to start ending this short presentation, by saying that in 2024, we had a debate on the International Neurotech Society annual meeting in Baltimore. And we asked all the neurotechs there, do we need new rights? And just 2% said definitely yes, just 11 probably yes, 25% not sure, 51 probably not, and 11 definitely not. So this is not a really popular idea. And Roberto, let's remember the EACME meeting. So I was with Roberto there in Zurich, and we made another interview. So we asked people of the European Association of Centers of Medical Ethics, what are the most important topics, most promising topics in medical ethics? And of 30 different topics, it was 30 different topics. Neuro-related topics were just the 25. So one of the most, unfortunately, not interesting topics for them. So even in academic settings, this has not received enough attention that I think it should receive. But I want to end by how I started. So I was showing you some papers that showed the ethical challenges. But when you see the methodology of those papers and research, you're going to find that it has a lot of limitations. So for example, the paper research about decoding internal speech and thoughts only use 2 participants and require a lot of time for training purposes. And of those 2 participants, just with one, it worked, which was a 79% of accuracy in decoding thoughts. But with the other, it only reached 23%. So even when you train an algorithm and when you train all your research in fMRI, which is functional magnetic resonance imaging, it still isn't accurate enough to think that this is going to be a generalizable risk for the overall population, that they are going to read your thoughts. When we talk about the decoding of images of what you were seeing, it required at least 60,000 samples per subject of images, of 1,200 images presented at least 5 times. So this also requires a lot of training to do so. So this is not something that it is easily achievable, and also requires an fMRI, which is a big machine that costs a lot of money. When we talk about behavioral control, what this first requires a genetic modification of the neurons of the brain to make them photosensitive, but also it requires to have a very big cable implanted in the mice's brain. So maybe it's not too likely that in the near future they're going to control your behavior. And this is something that we know in human neuroscience. So if we used EEGs, which are wearables and easy to carry, the problem is that you have the lowest spatial resolution, so you don't get good information of the brain. With EEG, unfortunately, you're not going to get very good information of the brain, just some correlations of some waves with some cognitive functions, but you're not going to decode people's thoughts. It's not what EEG works like. So you get the lowest spatial resolution of the information of the brain. You have good temporal information because you get information in milliseconds, but also EEG is very tolerant for the people because you can carry as a wearable. If you want good information of the brain, you have to use fMRI, but if you use fMRI, it gives you good information. You have first a low temporal resolution, which means that EEG gets you information in milliseconds, but fMRI in seconds, but also it requires at least a medium or high tolerance, which means that you have to remain still in a big machine that you cannot carry around. So when you want good information, the problem is you have to either be inside a machine, remaining still, and if you want people to be able to move around with the device, well, you're not going to get good information. So that's like my hypothesis is, well, where are the real challenges of neuroscience? Maybe not in dystopian hypothesis of the future, but rather in specific areas that we might need to revise, which is especially in medical and commercial applications, direct-to-consumer applications, and in judicial settings. That's why we've been saying that maybe we don't need to focus on creating new list of rights, but rather to understand whether we need new laws, specifically in some areas, and maybe focusing in privacy regulation, on consumer law, and uses in criminal law. Thank you very much for being here, and thank you, Eduardo, for the time.
Thank you. Thank you. Was very interesting. You touch one of my favorite things, which is the controversy between if we need new laws, new regulations, or we need to apply what we already have, which is a problem. I used to be the data protection authority in my country, in Argentina, and we have a lot of laws. And the problem was that sometimes it was very difficult to apply those laws because we don't have the capacity to enforce the laws, to do the investigations and these kind of things. I probably we are going to have another discussion about this with Roberto, who is in the next panel. I would love to have that discussion. We invited Rafael Juste to this event. Unfortunately, he couldn't come. Probably we are Jared from the Neurotechnology Foundation. He accepted to be here. He's going to be in the next panel, so we can have this discussion again in the second panel. But let me say something very briefly before going to Brittan. I'm glad that you raise the importance of neurotechnologies in the health sector and what are the things that are possible to do using neurotechnologies for some diseases like Alzheimer or Parkinson. You raised the issue about ethical problems that we have in that sector as well, and I totally agree with you. It's interesting, this idea of thinking in new rights about that, and as our colleague Chris Boblitz, that was invited to this symposium and couldn't come. The same with Marcello Yenka. He mentioned this idea, the problem of neuroexceptionalism that you put on the table. If we start talking about neuro rights, it will be that exceptional and problematic, and the rights inflation is the other problem. So I was when I started working on this, my first debate was with Rafael Juste and others about the needs to new human rights, and I said we don't need new human rights. The human rights that we already have protect the misuse of neurotechnologies. And I was totally impressed with an old article coming in the Financial Times from Susie Alegre, that she said exactly that we don't need new laws, we need to apply what we already have. So with that, I'm pass the floor to you, Brittan. You have time to express your views before we do a break. Brittan?
All right, thank you, everybody. With that introduction, I will talk about the laws that we do have in the United States and sort of give you that patchwork quilt, going from proposed federal laws to different state laws to laws that will be enacted in 2026. Some of what I was going to say has been covered brilliantly by other people, which is great. So I also will talk to you about some of the trends in the creation of these laws, so we can try to anticipate a little more where they're going and understand how to classify them. As Diego said, we're moving beyond clinical to consumer controllers, looking at earbuds and headbands and wristbands that decode neural intent. But when you look at this internet of bodies and minds, it really represents a paradigm shift from external privacy, looking at locational and behavioral, transactional behavior, to internal privacy. When you look at neural data in the US regulatory landscape, if you remember one thing from this lecture, remember that you want to see what the locus of the law is. Is it regulating the signal, or is it regulating the source? And those are the two ways that you'll see different US regulatory landscapes going. First, you have an anatomical approach, and you'll see this in Colorado and Connecticut. And these states focus on the physical origin of the data. They look at information that concerns the activity of the central or peripheral nervous system and can be processed by a device. Um, the the nuance here is by including a peripheral nervous system, these laws capture data from wristbands that measure EMG signals from the arm. And some argue that this can be used to infer intent. The second approach is the generational approach, and you see this from the California CCPA law. And this is a narrower, more technical filter. And its definition is information that is generated by measuring the activity of a consumer's nervous system. It emphasizes the act of measurement. So if the data is inferred rather than measured, it may fall outside this category. When you look at the laws, there's a significant legal loophole in neural privacy in how non-neural data is defined. And you kind of got to get your mind around this. It's not how we actually define what neural data is, it's what's excluded from that, and sometimes explicitly. The excluded physiological definition is favored by California and Montana. And they have explicit lists of what is not neural data. And this creates a safe harbor for companies who wish to collect behavioral data. And what is excluded here is heart rate, blood pressure, motor activity, breathing, and pupil dilation. Now, these may be covered under other systems of laws, but we're just talking about laws explicitly designed to regulate neural data here. I'll describe more in depth later in some of the critiques that I've written on other type of spatial and wearable computing. This excludes certain type of spatial computing, and it creates a diagnostic trap. For example, since pupil response velocity is a biomarker for Alzheimer's risk, and I'll get into that a little more. Excluding it as non-neural allows companies to identify cognitive decline while bypassing neural privacy laws. Oops. The Mind Act is also uses an inferred mental state definition. The Federal Mind Act is a proposal, and it encompasses a functional split. It acknowledges that data like eye tracking or gait is technically non-neural, but it classifies it as neural-related if it's used to infer mental states. And so this includes typing patterns, voice analysis, and eye tracking. Nita Farahani highlights that there's also loopholes here, and she uses the example of typing rhythm, so your cadence and your key, the time you hold the keys, as dispositive for detecting Parkinson's disease. The Mind Act would seek to protect this type of data as neural because of its output, even if its input is non-neural motor activity. I have some charts that I'd be happy to share with people later, but when you look at the Mind Act, features like pupil dilation, motor activity, heart rate are all included, and they are excluded in California, Montana, and potentially included if they're used for identification purposes in Colorado. What this belies is different privacy strategies, where the Mind Act proposal is rights-based or inferred privacy. California has a narrow technical bend. Montana has a broad anatomical bend, and Colorado has a tiered or biological bend. California, Montana, and Colorado define neural data to exclude data from to include data from the central and peripheral nervous systems. While other states like Connecticut's new law limits its definition to central nervous system data only. There's also variations, which we don't have time to get into today, about whether algorithmically derived data is included. There's a federal gap when you're looking at US privacy law, and the foundational error that comes about when you're looking at neural data is that in US privacy discourse, there's often a misbelief that health data is a protected category regardless of who holds it. In reality, US law protects the institution and not the information. And by that, let's look at HIPAA. Sometimes I call it the HIPAA mirage. There's entity versus data. HIPAA protects data when it's within covered entities like hospitals or from doctors. When a consumer buys a neural wearable, like a Muse headband or an Apple Watch with neural sensing patterns, when they buy this from a retail corporation, they're entering a regulatory vacuum. There's a commercial loophole. If a user wears a sleep tracking headband from a startup, then that data is purely commercial. And so it lacks the fiduciary protections of a medical record, even if the signal is identical to a clinical EEG. The FTC can try to step in with its Section 5 authority. They're currently the policeman on the beat, but it's reactive and kind of cabined under their unfair and deceptive acts authority. It can only intervene after a company breaks a privacy promise or causes substantial injury. And there was a congressional call to action in April 2025, where Senators Cantwell, Schumer, and Markey have formally called on the FTC to use Section 5 authority to investigate whether neurotechnology companies are engaging in unfair or deceptive practices. And the Office of Public Affairs confirmed receipt, but provided no comment to this point, highlighting the agency's uncertain enforcement posture. The biggest loophole in existing US federal law is the intended use loophole. And the FDA regulates based on claims. So if a brain-computer interface claims it's supposed to treat depression, it's a medical device. If it claims to enhance focus, it's a general wellness product. Earlier this month, in January 2026, there was a policy update where the FDA revised its general wellness guidance to allow wellness products to output complex physiological parameters like heart rate variability or blood pressure without medical grade clearance, provided they avoid diagnostic claims. And so this creates a regulatory arbitrage where identical technology receives different protection based solely on its marketing. The FDA will allow, for example, estimation via optical sensing for parameters like blood pressure or glucose in wellness testing. Previously, the FDA would use an inherent association doctrine, arguing that certain biomarkers are inherently medical, but by relaxing this, they're creating a secondary market that is legalized for sensitive biomarkers that are medically accurate, but legally wellness only. And this will bypass privacy protection of medical grade devices. On state-based, and I know I'm gonna, I probably have about 5 minutes left. Is that right, Eduardo? Okay, so there are 3 laws on the books in the states, and you see the rise of sensitive personal information. There's a broad approach from Colorado. It was the first to explicitly add neural data to the definition of sensitive data under the Colorado Privacy Act. And it covers any measurement of the activity of an individual's central peripheral nervous system that can be processed with or with the assistance of a device. There's an opt-in mandate, so any entity collecting neural data must obtain affirmative, clear, and unambiguous consents. Silence or pre-check boxes don't count. And it's notably, biological data only applies when it's used or intended to be used for identification. So it narrows the scope compared to other states. California also has its law on the books, and it classifies neural data as sensitive personal information. It grants consumers a right to limit, and this is what makes it different than other states. You can tell a company, you can use my brain data to run this device, but you can't use it to build an advertising profile about me. There's also workplace protection in California that differentiates it from other states. It extends laws to employers that prevent them from mandating attention monitoring headbands without meeting significant legal hurdles. And you don't have this protection in other states. Montana has a law about neural data, but it's under genetics. So they integrate neural data protection into their Genetic Information Privacy Act rather than a general consumer privacy law. They have a probable cause shield. They prohibit government agencies from obtaining neural data without a search warrant or an investigative subpoena based on a finding of probable cause. And they have storage restrictions. So they explicitly prohibit storing data in countries designated as foreign adversaries. There are 2 laws that are about to be enforceable in 2026. One is in Connecticut. There's a proposal that's coming into force about the central nervous system scope. Under the Connecticut law, SB 1295, it limits neural data strictly to information generated by the central nervous system, and as we talked about, that creates challenges with wristbands and other wearables. Maryland's Online Data Privacy Act will be enforceable in 2026 as well, and they're the first to use a strictly necessary standard for sensitive data. This will prevent companies from collecting any sensitive data, including mental health biomarkers, unless it's required for the device to function. So it's a bit a bit peripheral, but not really. There are more proposals coming out. There's 9 proposals, 9 states that deal with neural data. And the important thing to watch for in statutory proposals is whether or not they protect the signal or the inference. Minnesota has a human rights-based proposal where they explicitly prohibit using neurotechnology to manipulate brain activity via electrical or optical stimuli without the conscious awareness of the individual. So this is a codification of explicit rights to mental privacy, cognitive liberty, mental integrity, and psychological continuity. It also modifies computer damage statutes to create felony level penalties for unauthorized access to systems containing a brain-computer interface. Massachusetts has a civil rights and inference-based proposal where they define neural data to include derived data and inferences. So this targets the gap where mental states are decoded from behavioral proxies. They add an anti-discrimination mandates and include a private right of action for enforcement with significant penalties up to 4% of the annual global revenue. So it's emphasizing civil rights over mere consumer data protection. Vermont has a series of laws that are coming in that can all touch neural data, and they have accountability and fiduciary rights. They create a neural fiduciary duty, introducing a duty of care for entities holding sensitive data, suggesting a fiduciary-like responsibility regardless of medical versus wellness marketing, and create a data broker registry requiring companies to monetize neural inferences to register as data brokers. And then they establish a statutory right to freedom of thought and protection from unauthorized neurotechnological alterations. Finally, Illinois is proposing a liability integration proposal into BIPA, so proposing legislation to include neural data as biometric identifiers, and also creating a private right of action, allowing individuals to sue for statutory damages without needing to prove financial harm. So a big patchwork, and you see a difference in the governance and philosophy focus of these statutes. Some statutory bases are in consumer law, some are in genetics, others are in privacy and rights-based. But the focuses range from identification to the right to limit to warrants and data storage, all the way down to liberty, civil rights, and liability. With my last minute or two, I will very quickly say the federal response to this patchwork is the MIND Act. And this was introduced in 2025, and it seeks to establish a national floor. There's an inference clause that explicitly targets related data like eye tracking, gait, and voice that is used to infer mental states. That's directly addressing the loophole that I had identified in some of my prior work for different technologies. It closes that HIPAA loophole to treat consumer neurotech data with the same gravity as a medical record. It has national security implications about brain control weaponry by foreign adversaries. It codifies this sense that neurodata is uniquely sensitive, signaling to courts that it might warrant Fourth Amendment protections. And then I'm going to kind of summarize that in later panels, they can talk about different scholarly critiques about moving from privacy law to human rights. So I've talked about the loophole where you want to make sure you are not creating Cambridge Analytica on steroids by carving out behavioral and inferential applications of the data. And if the law only protects neural signals, companies will use non-neural proxies to achieve the same invasive decoding. And I'm sure somebody in later panels will talk about Nita Farhani's cognitive liberty framework, so I don't need to go into that. But those are 2 philosophical rights-based frameworks that you can use to really approach this patchwork of state laws, proposals, and federal laws in the US landscape. I know that was really dense and really quick, but I'm happy to have discussions with people afterwards and really appreciate the invitation to present here today. Thanks.
Thank you very much. Thank you very much. It was fast, it was dense, but important because we can link your conversation with what Diego, for example, said, or with Alex also. I mean, there are a lot of regulations out there controlling these things, and Koy can attest that the private sector knows about that regulations and working under those frameworks. So it's a little bit complicated when we start thinking in new regulations for new technologies because this could be, a never-end story. This is my position. You, Brittan, mentioned all the U.S. protection, or many of the U.S. protection, the federal gap that we have been discussing with U.S. scholars as well. But there are a couple of things that you mentioned very quickly that are problematic all around the world. One is consent. How we are going to deal with consent on these technologies. Informed consent, what that means, is important, it's not important. I mean, consent is a problem from all of us who are working on personal data and data protection because we try to say that we are safe if the data subject give the consent, but what that means. I mean, we are giving consent every day on every application, and are we safe just because of that, or is Daniel Solov have our colleague here in Washington have this idea of the 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 paradox of privacy. I think that he called this a privacy paradox or something like that. But and the other thing that you mentioned is sensitive information. How many regulations are including this kind of data as sensitive information? And in the case of the Inter-American system, the Inter-American Juridical Committee also included neurodata as personal data and sensitive data. So this is a matter of decision and how we are going to define sensitive data, but we can have a more discussion about that. We have some minutes before the break, and I would like to give you the chance to react just in 1 minute, please, or to say something else or something that you hear and you want to say something in the same order that we started, but please 1 minute. I don't want to start putting. I don't know if the signs that I'm putting on the screen are you can see them when I put time. But please, just 1 minute each of you. We start with you, Jen, and we move forward in the same order. Just 1 minute.
Yeah.
Thanks.
I mean, thank you to all my amazing panelists. I think what all of our conversations have highlighted is just the real need for multi-stakeholder conversations, as I mentioned in my presentation as well, that having these interdisciplinary conversations about and drawing expertise from all of these different sectors is really critical because we're all adjacent to the core conversation. So having insight from all of the different sectors is really important, and integrating all of them into one standard framework will be incredibly difficult, but I hope very worthwhile. So yeah, thank you so much to my panelists. And thank you, Dr. Bertoni.
Alex?
Yeah, so just quickly, it's been a fascinating conversation. I agree that it's a multi-stakeholder problem. It's great that Koy is here for Meta and that companies are exemplifying good practices in this area and behaving very responsibly. So I think that's critical. The other thing I would say is that tech moves so fast, and this area is going to keep on advancing so quickly. I do worry that if we spend too much time trying to come up with new laws to regulate the state of the tech of the art today, that we'll get that wrong. And my inclination is to to look at existing human rights laws, existing privacy laws, and make sure that they encompass the various implications that we see right now with neurotech.
Thank you, Alex. Koy?
Yeah, thank you. I just want to reiterate my thanks for being invited to participate on this panel and express my thanks to my co-panelists who are also impressive in terms of the knowledge and the work that they're doing in this area. And I do want to agree with Jennifer and Alex's comments that this is a multifaceted issue that requires multidisciplinary engagement and coordination. And I also want to say that, I agree that oftentimes innovation moves so fast. It's really important to have input as a company like Meta. It's really important to have input from a large, diverse group of stakeholders so that we can understand, what all the concerns are and we can, implement course correction if we need to, or get those actionable insights that we can pass on to our product teams. That's a really important aspect of what we do. So I'd love to invite this group to continue the conversation. Please reach out to me, engage with me, and I'd love to get your feedback and your thoughts and hear about new papers you're doing, new initiatives that you're leading, and continue this conversation.
Thank you very much, Koy. Diego?
Thank you. This is a very interesting conversation we're having. I think my main take of this, and also being in Latin America, is this is something very weird. For the first time, Latin America is a region that is leading the regulation of new technologies, which is something very interesting, but at the same time, very paradoxically. At the Universidad Externado, the last week, we had a very nice congress that was called the Neuroscience, Neurotechnology, and Human Rights Conference. We had, for example, Christoph Bublitz with us. We had many professors from Switzerland, from Germany, from the Netherlands, discussing for the first time in one of our universities. And maybe one of the first thing I said was, before having a discussion on new technologies in Colombia, we need to know exactly where we are situated. We are situated in a region that is profoundly unequal, violent, in a very impoverished context. And I even invited the president of the Colombian Society of Neuroscience, who basically shows us what the real state of the technology is in Colombia. So we have to adapt to our context. And I think the most important take is also to have an interdisciplinary conversation before rushing to legislate, because maybe something worse than having no regulation is having a bad regulation.
Thank you very much, Diego. Totally agree with that. Brittan, last words? A lot of responsibility.
Much regulation. Where I did not relish my task of trying to lay out the weird U.S. legal framework for you because it makes very little sense. But I do hope what was clear after getting into all the jargon and all the depth is that the debate about whether or not we regulate the signal or the source is going to continue to be increasingly salient, whether or not we're applying that to existing laws or to new proposals for regulation. And I think the salience of that will continue to grow as we see new developments in new forms of AI that allow us to make behavioral or inferential assumptions about people based off of this new category of data. So I think we're all early to the playing field here, but actually not too early, which is a good thing, even if the weather does not help us meet on the same actual playing field. So
Okay. Well, thank you all. That was an excellent panel, an excellent conversation. I really enjoyed. I'm sure that all this information will be very useful for the community that is working on this, and particularly for students that want to start working on technology and human rights and working on a specific technology, which might be neurotechnology. So thank you very much. You were awesome. The presentations were great. I'm very happy. My only frustration is that you are not here, but that's life. So we are going to do a short break, 15 minutes break. We'll resume 11:45 here in Washington, D.C. It's 10 minutes, not 15. It's 11:35 now. So in 10 minutes, we are back. Of course, you are invited to maintain and to hear the second panel, which also be very, very interesting and is connected because we were discussing some things about what's going on in the United States, regulation, no regulation. Diego opened the conversation on what's going on in Latin America, but the second panel is more what's going on in the world on this issue. So I invite you to stay here, and in 10 minutes we resume. Thank you very much. Okay. I hope that everybody's there. I would love to have all the panelists in the screen. So I have Roberto and I have Jared. Hi, Jared. How are you? Milena. And we are missing David. I guess that David
I'm here.
should be. Okay, can you put your camera on, David, if you don't mind? So all the panelists will be here. So thank you, David. Thank you very much. I am really enjoying this event. And sorry to repeat again that I'm very sorry about you don't have the chance to have this event in presence, but Mother Nature is powerful and decided to have a very big storm this week. And the university decided yesterday evening, to close the law school. So we need to move forward to have this event in the normal pandemic, way, if I may say. We had a lot of these kind of meetings during the pandemic, so it's a little bit of a backlash. But the conversations are great. So we are now in the second and last panel. We are going to talk about neurotechnologies around the world in general, but the panelists can touch other issues as well. We have an excellent panel here. I would like to do the same of what I did for the first panel, which is make a very brief introductions about all of you. In this panel, we will have Milena Costas. I met Milena for the first time in Berlin in a meeting organized by our friends Chris Bublitz that was mentioned by Diego in the last panel. And we were discussing about neurotechnologies at the UN level because Milena was at that time the rapporteur in the Human Rights Council Advisory Board, and she has been working on a document for the Human Rights Council. She has an international degree in legal study from the University of Madrid. As I said, I'm not going to read all the CV of all of you, but I'm very happy to have you, Milena, because I remember that in Berlin we were talking about what's next. So next was here in Washington. Milena is here. Milena arrived. Is coming from Europe, and she arrived just in time. So I'm glad that you are here, and at the same time, I'm sorry that you are here. But this is what happened when the university closed. You were already here. So thank you for coming. We also met with Jared in Berlin at the same meeting, and he did a very great presentation about what the NeuroRight Foundation has been doing. As I mentioned in the previous panel, we also invite Rafael Juste to this conversation. Unfortunately, he couldn't be here, but we have the pleasure to have Jared here, and he can tell us what is the position or what they are doing around the world in terms of neurotechnologies regulation and these kind of things. He is also the managing director of Perseus Strategies and the general counsel of the NeuroRight Foundation. and member of the advisory board of the Carl Ryan Center for Human Rights at Harvard University. So Jared, your CV said much more about you, but I apologize if I'm not telling all the important things, but what is important is that you're here. Then we also have the pleasure to have my other colleague and from Argentina as well, but he has been working in Europe for many, many years, as far as I understand, Roberto Andorno. Roberto holds a Doctor of Law degree from Buenos Aires University, like me. So we are, classmate or for our UBA, University of Buenos Aires. But he has a second Doctor of Law degree from University of Paris at, my friends is awful, Paris est Créteil. So you have two PhD, excellent. And I am interested to hear, and I invited and I was following Roberto works on neurotechnologies and on technologies and rights extensively and human rights for some time. But one thing that is important for this panel is that Roberto was a member of the UNESCO International Bioethics Committee on behalf of Argentina and participated in the drafting of the International Declaration of Human Genetic Data and the Universal Declaration on Bioethics and Human Rights. And you were also working on neurotechnologies, the new neurotechnology document issued by UNESCO. So it will be a pleasure to have you here in this panel. Unfortunately, Roberto, we were trying to meet each other when I was in Geneva a couple of months ago. We didn't have that opportunity. I invited you to come here. Mother Nature impeded that, but I'm pretty sure that we will meet in person very, very soon. And last but not least, as we did in the first panel, we have the pleasure to have David Lehr. David is from Meta, leads the Meta's response to privacy legislation at the state and federal level in the US. He also developed the company thinking on how laws and regulations globally should approach issues related to sensitive data. So it will be great to have also the perspective from the private sector here with David. So I stop there and we are going to move in the same order that I introduced yourself. Please, 15 minutes each of you. If less, we will have more time for discussion and pay attention to these awful signs that I am going to put when the time is or I'm going to put a 1 minute sign if it's necessary as well. So Milena, the floor is yours.
Thank you very much, Roberto. Eduardo, just making sure that you can see the presentation. Is that okay?
Yes.
Yes. Is
I
that
can
okay
see.
for you? Yeah,
Yes.
then I have to, okay, here. Okay, I think it's okay.
Yes.
So first of all, thank you, Eduardo. Yes, it's a pity that we cannot be in person. Also for the students, it would be a great pleasure to meet them. But thank you very much for the invitation. Thank you to your team, to the Institute also, to Jordan, who was like arranging all the trip. And you asked me to be a bit descriptive on the process that is taking place before the Human Rights Council. So I wanted just to present, I want to tell the students we are just presenting a piece of the whole puzzle that is taking place and that we have to gather and to build together in order to make sure that we are developing these technologies for the good. So I wanted to start by referring, first of all, to a quote of a statement that it was very interesting in the 2016 World Economic Forum in the first day of the introductory speeches, were the founder of the World Economic Forum. I'm not a fan of this World Economic Forum, not even from the founder, but I think it's quite significant what he said. And he said he introduced this idea of the fourth industrial revolution. And he was stressing that and saying that never before has there been a more promising or more dangerous moment. And he explained that this new revolution, in his most pessimistic and dehumanized form, has the potential to robotize humanity and to rob us our heart and our soul. And he said, okay, there is also a positive version, which, however, can serve to complement to the best parts of our human nature. For example, creativity, empathy, stewardship, and also elevate humanity. So I think it's important that we start with this frame, because I think we have still today this dual vision of technology, that there is technology for the good and technology for the bad. And I think this is one of the assumptions that makes difficult for us to regulate or to approach or to create a framework for governance. Of course, we have also at the UN, we have many discussions taking place focused on AI today, which is obviously very much linked with the advancement and the worries today, or the concerns about neurotechnologies, which is neurotechnologies, the most advanced neurotechnologies being introduced also through the commercial or consumer-directed devices, is this merging with the AI technologies. So at the global level also, I think it's important to make a broader overlook to the possibility or the impact that these technologies will have over security, peace and security, international peace and security. We had Alex, Joe before talking about national security, but I think it's important not to lose the sight on what can happen with the introduction of this technology in the military domain. And of course, the General Secretary of the UN is warning from many years now on this use of technologies for the wars. And he was just past year in the General Assembly warning about that new technologies must serve to the humanity and not hinder the humanity. So just to say that we are focusing on Geneva, where most agencies and the main body of the UN on human rights, which is the Human Rights Council, meets for different sessions during the year. And of course, is the second, let's put a headquarters of UN. The others, as you know, is in New York. So we have this very broad system, which has been developed since the creation of the UN. And now we have two kind of main approaches to the human rights promotion and protections, which are the treaty bodies that you might know, that are those committees of the UN, which are making sure that the states implement correctly the different instruments at the international level on human rights law protection. And then we have these political bodies. And the main body, which is very high level within the structure of the UN, is the Human Rights Council. And this is the main intergovernmental body, so it's made up from representatives of states, and takes the most important decisions on human rights questions. It is made of 47 states. These states, I mean, the composition is variable because there are elections every 2 years. And as you know, states might take decisions and might take resolutions on the different situations, human rights situations around the world. But they also listen the different reports presented by special rapporteurs, which are appointed by the Council. And these special rapporteurs also can make, propose new topics for the consideration or call the attention of the Council on new topics where they think that there are worrying patterns on human rights perspective. There is also an important body within the structure of the Human Rights Council, which is this advisory committee, of which I was a member until October past year. And we have this mandate to implement the different or to develop different studies at the request of the Council, and we can also make certain proposals to them whenever we find an issue that should be put on or should be dealt by the Council. And that was the case with the neurotechnology. The neurotechnology came because, we discuss within the advisory committee different topics, and when we pick a topic which we think it's very important to address to the Council, we make a proposal for a research proposal. We say it like that. This advisory committee, as you see, is is made up of 18 members, which are completely independent. We are not, we don't represent the state of our nationality. And we work in complete integrity, autonomy, and independency from states, but at the same time, we are within the structure. So we listen very much what's going on, but we engage also civil society to participate, the academia. We also interact with companies or with private sector just to listen, and we produce some kind of very broad reports to provide an overview to the Council on the topic that has been selected. So we work as a think tank, and as I say, we could propose this research, and that was why I took the initiative to propose, first of all, to the advisory committee, and then we submit this initiative to the Council, and it was accepted by the Council. And this comes from obviously all the, I would call, neuro rights controversy. I found this article on a newspaper saying we need a new universal declaration on the neuro rights. And I was shocked about this, headline in the newspaper. And that's why I started to make my research. And I found out, obviously, all the work of the Neuro Rights Foundations. I found out that Roberto Andorno and Marcello Jenka had proposed also this framework for neuro rights. I found also all the explanations of Rafael Juste everywhere. So I was like really thought that was the topic. And I was very shocked about knowing that the UN had not been dealing with this, and that this topic, for example, was arrived to the UNESCO and to other bodies, but not to the main body dealing with human rights, which was the Human Rights Council. And I thought it was very necessary that this topic arrives there, because all the states of the world will be discussing on the topic. And finally, it's a way also of raising awareness, but also to trigger the discussion for what is the framework we need, and what are of course, the national regulations, and in what topics, where are the gaps, the legal gaps, what kind of regulations we need or not. So finally, we get, after this presentation of the research proposal to the Council, we get a mandate in 2022, and there is a resolution asking us for develop a study or a report on the impacts, opportunities, and challenges. So it was like a very broad overview that we presented, but we focused mainly on the impacts and challenges, in the sense that we also address in the report all the opportunities. But what we thought it was that at this moment, the most important thing is how to address the risks in order to open the possibilities or the opportunities. Of course, we knew all the advantages at the medical level, at the level of understanding how the brain works, but at the same time, I honestly thought that there are so many difficulties already for the implementation of the framework we have. I mean, we have a lot of declarations, we have a lot of treaties, we have a lot of regulations, but we need much more focus on implementations and in bodies with the technical capacity and also funding for these bodies to be able to, overview what's going on, monitor, and also address the risks, and also protect people from potential misuses or abuses. And here we are focusing mainly on companies, but knowing that the state is the one who has the main responsibility to implement human rights obligations within their national jurisdiction. So we also wanted to build this bridge in between international law and national law, but also this knowing that this bridge has to be built by not only states and not only private companies or private sector, but also that academy or also the civil society has to be there. We provided action-oriented recommendations, and it was very significant that we have the adoption of this resolution by consensus, which means that no state from the Council opposed to this resolution. So that gives a lot of authority, let's put it like that, to this resolution. We had 4 states that were leading the negotiation within the Council. They have to negotiate the text of the resolution, and these were Greece, Chile, Switzerland, and Singapore. So it was also very good that we had a very, very, very variado group of states coming from different regions around the world. And then it's very important also how many states are sponsoring, like declaring their support to this resolution. And we had more than 50 states from the Council. Also, main sponsors were states from WEOC and Gurulak, and that was a bit worrying in the sense that other states from Africa, for example, were not very engaged into the discussion, and also from Asia. But little by little, I think the importance of this resolution was that we managed to engage everyone in the conversation, and then obviously they have at the disposal not only the resolution but also the report that we made. So we look not into depth because it's like 20 pages report. We have a limit on the length, so it was very frustrating for me as rapporteur to write this down. But finally, we managed to address main rights that we thought they were like very, very engaged. And of course, in first line is privacy, but we thought that is not only a question of privacy. Yes, it's the first line right which is impacted by these technologies, but at the same time it's not the only one. And we were very focused on freedom of thought because it's the more overarching together with dignity, right, in this topic, and also of course personal integrity, non-discrimination, and all the rights we used to read there. But also we were focusing on specific rights of specific or particular vulnerable groups like children, persons with disabilities, and also the possibility for these technologies to debark into the workplace, and what would be the impacts, and how to avoid that this happens for the worst. So we identify all these risks, but also we wanted to make sure, clear, as I mentioned before, that we are addressing the challenges in order to maximize the opportunities. Of course, we dealt specifically on commercial applications. I'm not going into depth with this because you already mentioned, but it was one of the main issues that, the main shifts on neurotechnology that we noticed, and that was why we were talking about that, and also the dual use, as I said, and also the forthcoming and this very disturbing or troubling idea of augmented soldier that we found out that, for example, in different documents, strategic documents, for example, in the NATO, it is already integrated. That's something that is already, we don't know whether happening, but just within the different security and defense strategies and programs, this idea is already there. So that means that there is a real possibility that these developments take place, or at least as an objective of policies in this area. So we were also bringing this, as I mentioned, security, international peace and security framework to the conversation. So the main findings were that these neurotechnologies affect human rights in a unique manner, at least from the human rights perspective, that we need to integrate this human rights approach, which is a very common sense, I think, very basic ethical approach to the topic, but we need at least to integrate at this moment where the conversation is not starting, but in a very first moment into national and international policies. We need also to ensure or make sure that we are not undermining the little things we have, or the few things we have managed to get, which is all these human rights treaties. And so we highlight what was said before, that we have, or we think that this is adequate and flexible, which is very useful because provides a very flexible approach also in order to adequate or to decide what is the more adequate regulations. But what we need to make now is to make implementation certain. We also thought that it was needed a context-tailored human rights standards. So on the basis of these principles, very abstract, we need to ground them to the problems that we are facing and which are emerging. And the human rights bodies, both treaty bodies and also at the Human Rights Council, need to develop and interpret this or to adapt these principles to the new challenges of neurotechnologies. Finally, we said we need an international document which should be authoritative, just to guide the states on facing these problems, also at the national level, and also in order to establish a common ground of understanding, and also for them to avoid the fragmentation. Diego was referring before to that problem, and I think this is a real problem, the problem of fragmentation. Each state talking about its own language and about its own frameworks, and then we get something that is not enforceable at all in the different countries, and also because there are fragmentation and disparities, so everyone is talking about different things, and finally, not even at the legal, from the legal perspective, we are understanding what we are talking about. So the idea was this proposal to make a soft law document, and that what it happened. We get a new resolution, or the council adopted a new resolution whereby the council mandate gave the advisory committee a new mandate to develop recommended guidelines. That means in diplomatic language that, okay, let's see what you propose, and then we will decide whether it's it's applicable or not. But at least we are working on this document for recommending guidelines to the states on how the existing framework. So this also highlights that this idea that we have already what we need, what we have to do is to adapt this framework, very abstract, to the problems we are facing. And this applies, or we need to develop guidance for the whole life cycle of neurotechnologies. Again, it was adopted by consensus, which is very important. We had also in this in the format of the composition of the Human Rights Council, countries like you saw before, Israel, but also United States in the first resolution. In this one, we had also, for example, China. So, the big countries, let's put it like that, supporting the resolution, and the same core group. And here we have also sponsored, the resolution was sponsored by more than 60 countries. So,
Milena, your time is over, so we need
okay.
to
Okay,
close
you
now.
want me to finish?
Yes, please.
Yes, so just to tell you more or less what are the ideas that I think are important for these new guidelines, was this idea of we cannot just address one technology. We need, but at the same time, we don't have to lose the perspective that we are talking about a broader dynamics of technological convergence. We have to develop a framework which is anticipatory. And so this idea of introducing the precautionary principle and make it operative is important. We have to reinforce the human rights system. We are in a moment very bad, as you know, in all senses, but we have to keep going, and we have to be creative on see what is the manner to reinforce the human rights system, and also building instruments that ensure that the states are seriously engaged with this, but also obviously the private sector. So thank you very much.
Thank you, Milena. And we need to move forward fast to Jared. 10 to 15 minutes, please, if you can. Thanks.
Thanks so much. And Eduardo, very sorry that this isn't in person, but grateful for the opportunity to be with everyone virtually. I think it's fair to say that Milena pretty much covered the waterfront, so I think I'm going to be more like 10 minutes rather than 15. That was
sorry,
really...
Milena, we need you to go out your PowerPoint presentation. Sorry, Jared.
Yeah, no, so Milena did a great job kind of presenting the overall issues, of course, and so I'm going to try to just highlight a number of points that for the most part are going to be trying to supplement what she said rather than repeat it. So, by way of a little background, a number of people may know that when it comes to wearable neurotechnologies, that there have been really extraordinary developments in recent years. But even back in 2014, there was a person who was paraplegic who kicked off the World Cup by controlling a robotic exoskeleton wearing a brain-computer interface. An IndyCar driver was able to race an IndyCar. He had become paralyzed as well in an accident and was able to do that in 2021. And as scientific innovations have revolutionized our understanding of the brain, it's opened up enormous possibilities for economic development and also misuse and abuse. As Milena discussed, the UN has played a leading role here, regulating, beginning to talk about regulating emerging neurotechnologies. But of course, there have been lots of other multilateral organizations that have gotten into this work as well. The OECD, the Council of Europe, the European Union, the Organization of American States. All of these have produced guidelines and recommendations. But these kinds of efforts, in my view, need to be accelerated because the reality is that the future is already here. In the US, there's also been action undertaken, with California, Colorado, Montana, and Connecticut being the first to update their privacy laws to include neural data and the definition of sensitive data. I think it's really important to start to understand in addition to the international law issues, why is this ultimately going to matter? And probably the best example of this is that, when you see what's happening with implantable neurotech devices, anything that can be done with an implantable device today will eventually be able to be done with a wearable device. And in 2023, using an implanted BCI powered by Gen AI, a paralyzed woman was able to speak for the first time in 18 years after suffering a stroke. And the technology decoded her inner language at about 85 words a minute, 95% accuracy, and projected her emotions and intended facial muscle movements onto a digital avatar. The reality is that that even just when it comes to wearable devices, there are a wide array of neurotech products already available and on the market. And these include devices that do things like track stress and energy, attention level, mood, meditative states. There are devices that combine neurotechnology and gaming, like a product that can enable you to fly a small helicopter drone with your mind. And then, of course, Apple has a pending patent for its next generation AirPod, which will have a built-in EEG scanner in it. But as these devices grow rapidly, legal and ethical concerns are also rising. And so a number of years ago, there was a lot of public reporting around the use in China of a head-mounted device from the US company BrainCo that school children were required to wear to monitor their concentration levels. And the devices display different colored lights for different levels of concentration. As was mentioned earlier by Eduardo, when it comes to the conception of the term neurorights, of course, Marcelo Ayenka and Roberto on this call published a major piece in 2017 on neurorights. At the same time, my colleague Rafael Yuste at Columbia had convened a group of 25 people from around the world that were experts on emerging neurotech, including the heads of all the global brain initiatives. And they published also that same year a peer-reviewed article in Nature, where they, on the one hand, talked about the important advances in neurotech and how it could revolutionize the treatment of many conditions, but also they cautioned that the technology could exacerbate social inequalities and offer corporations, hackers, and governments, or anyone else, new ways to exploit and manipulate people, and even alter core human characteristics. And this is how, collectively the term neurorights was adopted. As an international human rights lawyer, when I got into this work about 5 years ago, it was really important for me to clarify that, at least as I see neurorights and as the Neurorights Foundation itself sees neurorights, we really are not talking about new human rights, but rather the application of existing rights and in some cases their further interpretation. And in essence, there are 5 areas of concern that we have as a matter of international human rights law, which includes the right to privacy or mental privacy, a right to mental agency, a right to mental identity, a right to non-discrimination in the development and application of neurotech, and a right to fair access to mental augmentation. But it's important to appreciate that even just guaranteeing a right of mental privacy as a start will be a challenging road full of complexity. While implantable neurotech devices are regulated as medical devices and the data collected by companies is protected under generally a country's health data privacy laws, the market for wearable devices is growing quickly, and these devices are considered consumer products or consumer electronics and don't have any protections. And this is a very, very serious problem because neural circuits in our brain create our thoughts, our emotions, our memories. They guide our decision making and they form our personality, identity, our sense of self, and even our subconscious. And this means that the medical grade neural data being collected and analyzed in consumer devices can reveal deeply intimate information well beyond the intended use of these products, including about medical conditions or mental states. To get a sense of what is coming, there's been publicly reported a device in Australia that has combined a wearable EEG scanner with Gen AI to decode thought to text in a wearable device right now at about 40% accuracy. And as this device and others are perfected, there's every reason to expect in the coming years we'll be able to send text messages decoded from our inner language. This I think is going to be quite transformative. And in my view, when this is capable of being perfected, that will really be the first moment in which the world will focus on emerging neurotech and the implications of it. there's going to be a lot of impacts on lawyers. We are here, at least virtually, at a law school. And just consider, for example, the potential impact of neurotech on criminal law. With a cutting-edge brain scanning device like Kernel Flow's brain imaging helmet, which is approaching the quality of an MRI machine, but in a wearable device. The development of a virtually unbeatable lie detector, may be imminent. In the documentary film Theory of Thought that we did with Werner Herzog, we used that device in an anecdotal way to show the visible and dramatic differences in brain scans of a single person lying and telling the truth about the answer to a simple math question. And imagine if criminal suspects could be regularly exonerated by agreeing to be questioned wearing such a device. But as an unintended consequence of the deployment of such technology, juries might also be more inclined to convict criminal defendants who do not choose that option, despite the required presumption of innocence provided by international law and national laws. And just to give you a sense that this is not, science fiction, I am a member, along with a number of others, of the outside expert group to a new Interpol UNODC project on neurotechnologies, law enforcement, and criminal justice. So, what do we kind of take from this, and what more needs to be done? Well, I think, to me, there are 5 things to say about kind of the way forward. I think the first one is that we need to look at updating interpretation of existing human rights in order to ensure that we're able to protect against potential misuse or abuse of emerging neurotechnologies. And to give you a concrete example, Article 17 of the International Covenant on Civil and Political Rights has a right to privacy in it. That treaty was drafted in the 1960s. It came into force in the 1970s. And their general comment interpreting the right to privacy under international law was promulgated in 1988. And the reality is that, if you can put yourself back into the shoes of the people that were drafting the ICCPR in the 1960s, of course, had they known that one day a person's forum internum could be breached, and we might be able to decode many things about a person from their inner operations of their central and peripheral nervous system, then, of course, they would have already embedded a right of mental privacy within the right to privacy. But the problem is that if you look to the right to privacy under international law and how it is interpreted, today the interpretation of the right to privacy is in essence a right to be free from an arbitrary interference with one's privacy. So it's quite straightforward that if, for example, a person was misusing an EEG scanning device and was decoding, for example, a person's health conditions, and then sharing those with a third party, that kind of action would quite clearly violate the obligation, of the right to privacy as currently interpreted in international law. But imagine a corporation, trying to, in essence, anonymize neural data and to use neural data to improve their own software. And the question really that's raised by that is whether that would be an interference with a person's privacy. And to me, on the face of it, it's not clear that it is. And I think that this is why there needs to be further clarification, which could be undertaken by the Human Rights Committee, the treaty body that is responsible under the ICCPR for interpreting the meaning of the rights under the convention. And in my view, you really do need to think about reopening the prior general comment and updating it for the digital age, which would include, in my view, a further interpretation of the right to privacy to include a right of mental privacy. Second, there's the importance of moving forward with additional soft law guidelines happening at a multilateral level. This is happening now. It will continue to happen, but it's very, very important to do so. This should very much be grounded in both international law and in science and medicine. And by that, what I mean is that when it comes to international law, we should look at, as I said, existing human rights and how the risks of misuse and abuse of neurotech can be addressed by the application of international human rights to the problems posed by emerging neurotech. But it also means that we have to ground the work that we're doing in science and medicine. And so, for example, there have been a number of people that have called for expanding the interpretation of what neural data is under international law to include information from non-neural biosensors. That's something that that the American Medical Association this past summer strongly opposed. it adopted a resolution at their annual meeting of their House of Delegates where they made very clear that there's a distinction between neural data, which is, a device that can, be captured and that can capture the activity of one central or peripheral nervous system, and non-neural biosensors, which is something else entirely and a very different kind of data. Now, it is true, of course, that certain kinds of non-neural biosensors do capture more sensitive data as compared to others. For example, an eye scanning device. And I'm not saying that those devices don't necessarily need to be regulated, but what I am saying is that those need to happen on a parallel track. And the reason, there are many reasons for this. I mean, one is to keep the science and medicine really focused on consensus views in the global community, but also in terms of the politics of getting movement on these kinds of issues. What we've found in our advocacy around the world is that it's very easy to explain what neurotech devices are, what neural data is, but that if you start to expand outward to really anything that can even indirectly or by inference decode a mental state, then it's a very slippery slope in terms of the need to potentially regulate almost anything. And you can imagine, for example, that one's television, if you're watching, let's say, a streaming service on your television, that a streaming service, let's say if you're watching TV from 2 a.m. to 5 a.m. every day, could decode that, in fact, you might have a mental disease of insomnia. And the question becomes, do you regulate your television because, it can be used to decode a mental state? And to me, that's a bit of a bridge too far. Third, I think in the longer run, as this work proliferates, we are going to need ultimately a new global agency to assist with supporting global regulation of emerging neurotech. That's probably more like 10 years down the road, not in the immediate term, but something that I think is important. Fourth, I think it's also important to not lose sight of the fact that really the big game here, as I see it, is really national and subnational regulation. At the end of the day, soft law standards are very helpful, but in the final analysis, all that really is going to matter in the long run is national and subnational regulation that can be guided by the soft law that's been developed at a global level. And then very last, and to conclude, of course, it's also going to be important to work with companies, neurotech companies around the world, and to ensure that they meet the very highest standards of international human rights and national and subnational laws and regulations. Ultimately, when you look at both Apple and Meta that's developing a device as well, they're going to be deploying wearable neurotech to hundreds of millions of people around the world and doing everything possible to ensure that they provide all the proper protections for the handling of that data and to guard against its misuse and abuse or it's being hacked and so forth is going to be ultimately very important. So let me just conclude there. And again, I tried to go in a bit of a different direction than Milena to supplement what she had to say. But again, thanks for having me, and I look forward to the rest of the discussion.
Thank you, Jared, for your presentation as well. It's great to have you here. I mean, you exposed the current discussion or what was the discussion. I'm happy that now we are moving the discussion to that we don't need new human rights, but we need fresh interpretation of human rights, which is something that is essential, particularly in the right to privacy, as you know, and the other colleagues know. I have been working with the Council of Europe, the Convention 108, with Marcello Yenka in doing some guidelines for the interpretation of the Convention 108 on this neurotechnology. So I'm happy to have you here because, I mean, it's good to have a conversation about what we need. You say in one part of your presentation, what's more to be done? And I think that this is the kind of goals that we should have in this kind of conversation with people that probably do not think exactly the same, but we want the same, which is protection of human beings. So this is great. So Roberto, it's your time. Please, 10 to 15 minutes, and we are very enthusiastic to hear you.
Thank you, Eduardo, and thank you for the kind invitation. I will try to share my slides. Okay, this one is it okay? Can you see them?
It is. We are seeing it. You need to put the slide move They're
Yeah.
known, yeah, but we are hearing yours. We are seeing yours, yes.
Perfect.
Great.
Thank you.
Now, that was perfect. Thank you.
So I'll try to, I will present the UNESCO recommendation, the very recent recommendation adopted in November of last year. But first of all, I like to introduce UNESCO very briefly, because maybe it's not much known, and what's the connection between UNESCO and human rights, and why this involvement in neurotechnology. And then I'll present a quick overview of this document. So first of all, why UNESCO? Why is UNESCO dealing with the ethics of neurotechnology? Yeah, I like to remind that UNESCO is the UN agency focused on education, science, and culture. It was created immediately after the Second World War. And in fact, the purpose of UNESCO is connected to science. So it's not so surprising that it's dealing with this topic. The purpose of UNESCO is to promote, to contribute to peace and security by promoting collaboration among nations in the areas of science, education, and culture, in order to promote universal respect for justice, for the rule of law, for human rights and fundamental freedoms. This is not very much known also, but UNESCO was in some way involved in the development of the Universal Declaration of Human Rights, because it had a committee on the theoretical basis of human rights. So a group of philosophers thinking about the possibility of developing a universal declaration of human rights. They conducted a survey asking thinkers of the time, etc. And the results of that survey were very encouraging, that there were values shared in different cultures that could support the development of a universal declaration. There is a nice statement in the headquarters of UNESCO in Paris. It's in different languages. That a statement that reflects very well this philosophy. It says, since wars begin in the minds of men, it is in the minds of men, women will say, that the defenses of peace must be constructed. So that's the idea, to promote peace through collaboration in the areas of science and culture and education, etc. So based on this philosophy, UNESCO developed a long experience in standard setting action in areas at the intersection of science, ethics, and human rights. It has an international bioethics committee since 1993, and that developed different international documents, declarations on genetics and bioethics and human rights, etc. A recommendation on artificial intelligence, and the recent recommendation on the ethics of neurotechnology. So I'll present now very quickly the milestones in the development of the recommendation on neurotechnology. The IBC, International Bioethics Committee, produced a report on this topic, a very long, comprehensive report in 2021, suggesting the need to develop an international declaration on the ethics of neurotechnology. Then quickly also, so the committee recommended a declaration, but then the UNESCO finally decided to adopt a recommendation. Both are different forms of soft law instruments. I will not enter into this, but so non-binding, immediately binding instruments. This so the difference between both is that declarations have a more, let's say, normative language, while recommendations use a more discursive, more reasoned language, not so much norms, but arguments. They present arguments in favor of certain principles. So in 2023, the General Conference of UNESCO decided that the organization should develop a recommendation on the ethics of neurotechnology. So it received the mandate. Why a recommendation and not a declaration? Because I think because of the good experience it had 2 years earlier with the recommendation on the ethics of artificial intelligence. Then one year after that, the UNESCO Director General appointed an ad hoc expert group on the ethics of neurotechnology to prepare a draft recommendation. The group was composed by scholars from different countries, from different disciplines. I had the pleasure and the honor to be part of that group. And there were legal scholars, there were neuroscientists. From the US, there was Nita Farahani, who is a really good expert in this area, Marcello Yenka, from Asia and Africa, etc. We met 2 times in April and August 2024, and prepared that first draft that was then submitted for consultation to member states, and then revised by a committee of legal experts to ensure that a document was in conformity with international law, and then the draft recommendation was examined for the last time by at an intergovernmental meeting in Paris. Well, finally it was adopted in November of last year. This is, in fact, the first global standard setting instrument on the ethical, legal, and social issues raised by neurotechnologies. It's a soft law document, as I said before. I thought of presenting very quickly some of the challenges posed by neurotechnology, although maybe it's not necessary now, because I thought of having students in the public. But so I will skip these slides, but very, very quickly mention that this challenge derived from this double 2 ways in which neurotechnologies interact with the brain, with the nervous system, by reading brain data and by writing on the brain, etc. See, from these 2 ways, a more passive and a more active, result a number of issues and ethical and legal issues, of course. From the point of view of privacy, the problem is that all these, or many of these neuro devices collect a large amount of brain data or neural data that can be potentially accessed and misused by third parties, by other individuals, employers, the state, etc., etc. These devices were proposed also to predict the risk of recidivism. They were proposed in the labor context to monitor workers' mental states and make decisions based on that. I had the opportunity to write on that particular topic, and Nita Farahani has in her book, The Battle for Your Brain, has also a chapter specifically dealing with this topic. It was proposed to also in educational settings to monitor children's brains to see if they are paying attention, etc., etc. So all this is, of course, extremely problematic. And this, just 2 words, because, yeah, why neural data? Because there's this discussion about neuro, how is called, you call that exceptionalism. I think that there are some reasons for granting specific protection to neural data. There are many reasons. One, more philosophical, I would say, is that they are very, very closely connected to our own personality, to our self. In particular, when they may potentially be used to reveal thoughts, memories, wishes, and mental states in general. This is not the case of other personal data necessarily. They can be used to discriminate. They can be used also to capture, to predict neurological conditions. So in this sense, these are also health data. And then some of these neural data are biometric identifiers, so that they can, like fingerprints or DNA, they may allow the identification of the individual, the source of those data. Based on, due to all these concerns, as it was already mentioned, I published a paper together with Marcello Jenka some years ago, proposing like a framework of human rights for dealing with these issues. Basically, it's not only privacy, as Milena already mentioned. It's not only mental privacy; it's broader than that. It's about cognitive liberty, so the self-determination, the capacity to decide by yourself. It's mental integrity. It's about personal identity, etc. Then I had the opportunity to prepare for the Council of Europe a report on European human rights law and neurotechnologies, and propose some recommendations, again, in the context of European human rights law. So now, a quick overview of the recommendation. After the preamble, it includes some definitions, then values and principles, and areas of policy action. The preamble is balanced in the sense that it recognizes, it acknowledges the positive side, of course, of neurotechnologies and the potential of these devices in terms of preventive, therapeutic, rehabilitation of neurological patients. But at the same time, it considers that these technologies raise ethical, legal, and social issues related to human dignity and human rights, such as autonomy, privacy, mental and physical integrity, personal identity, freedom of thought, risk of discrimination, etc., etc. So it tries to find a balance between these two sides. Regarding the definitions, it defines, there was a big discussion on this regarding what is neurotechnology. Some of the members of the group wanted to include here the so-called cognitive biometric technologies. Personally, I was against that. I thought that it could create a confusion. It was better to include into this concept only those procedures or devices that directly measure or analyze or modulate information from the nervous system, etc. So the recommendation adopts this view. But at the same time, recognize, of course, that these cognitive biometric technologies are also relevant. They can provide indirectly information about the neural activity, mental states, etc., which is therefore also so sensitive. And although they are not neurotechnologies per se, they raise similar issues than neurotechnologies, and therefore the same principles apply to these cognitive biometric technologies. In this category, you have eye tracking, typing dynamics, voice recognition, facial recognition, blood pressure measurement, etc., etc. All these are not neurotechnologies, but they may allow to collect, to infer some information about mental states. Well, very quickly. Then a section on values and principles.
Roberto,
Values.
if you can wrap up,
Finish.
because we are...
Yeah. So
Thank
very
you.
quickly, values, human dignity, human rights, etc. Then the principles, beneficence, non-maleficence, proportionality, autonomy, freedom of thought, protection of neural data, mental privacy, personal identity, etc., etc. Non-discrimination, etc. Then I'm finishing. It also tries to make some suggestions, recommendation for policy action, so it does not remain at a very only abstract level. And so it has some sections on the protection of vulnerable people, such as children and adolescents, older persons with disabilities, and specific sectors as healthcare sector, educational settings, labor and employment, consumer sector, etc., etc. Well, so now finally, the recommendation has some principles for the implementation, and so the idea is that now states should get some inspiration, some ideas from this document, and adopt to pass domestic laws in this area. Well, that's all. Thank you for your attention.
Thank you very much, Jared. Just complement with some thoughts about your presentation. Very interesting. It's very good to know what UNESCO. We saw the Human Rights Council. We saw UNESCO. We saw some sort of evolution coming in other countries, and in terms of theory from Jared. I think that this movement about working on neurotechnologies evolved from an original idea about we need new human rights. From now, we need the interpretation of what we have. This is under debate. I cannot say that the conversation is over, but it's an interesting conversation. The more important thing is, of course, as I said, maybe we need new interpretations. Maybe we need some sort of regulations. Maybe we need enforcement agencies. But if we do that, we need to provide those agencies with enough resources, because if not, we are creating things that we are approaching the end of this conversation. It was great to have you all here. I think that David touched on one of my favorite issues, which is, yes, we need some sort of regulation, but what kind of regulation? How we are going to transfer this kind of regulation in a way that is not going to, slow innovation or impede innovation on this kind of things. I have been talking about this for many years, including as I said, when I was a DPA in Argentina, and I proposed a new legislation for data protection in my country. And I always say the same. Yes, we need a new framework for personal data protection, but we need something that is not going to ban or to impede innovation. So we need both things at the same time: protect human rights, human beings, but also to trigger and to push for innovation. So, okay, we need to close this event. We are almost in time. I promise the people when we invited that we are going to finish at 1 p.m. Washington time. So we have one minute. We will have the benefit to see this event and to use this event for our, educational purposes in the future. We are going to put this event in our YouTube channel. Let me finish with something that is a little bit substantive and something that is the normal way to finish this kind of event, which is to say thank you to many people. So in terms of substantive issues, as I said at the beginning, we at the center have been working on technology and human rights. Actually, I'm teaching technology and human rights here at the EU, and one of the issues in terms of these technologies that we discussed today, which is neurotechnologies, is regulations or not regulations, new rights or not new rights. This kind of discussion is an open discussion. I think that there is some sort of consensus now, including in our conversations today, that what we really need is a good interpretation of what we have. What we really need is enforce what we have in a good way. And that will be essential. Let me share with you something that I just read this weekend before the storm comes. It's a piece. It's something that was published at The Economist, and I mean, when I read it, it comes to me. One approach that is coming more from Europe, and it's important for me to read it here because can be some sort of wrap up of some part of our conversation. It is an article in The Economist, and they said, what could slow the European down? One risk, as usual, is regulation. Policymakers in Brussels have so far focused most of their energy on preventing the technology from wreaking havoc, resulting in the EU Artificial Intelligence Act. It sets a global benchmark for safety and data protection, but critics says it creates too much red tape and will slow down innovation and adoption. Although a full reversal is unlikely, in November, the EU pushed back the implementation of some burdensome parts of legislation after complaints from business. Bosses are hoping for a simplified approach that would provide clarity over what they can and cannot do. That, in turn, would encourage investment. So this is the conversation that we are having today. And I think that in a law school, we need to think in regulation. We need to think in interpretations, but it's important to have these ideas in mind. And this is, of course, my perspective. I'm not saying that this is the perspective of all the panelists here, but it's good to have people thinking on different point of view and have these kind of discussions for the benefit of the people, for the benefit of human rights in a moment that we need to strengthen human rights and not to diminish the importance of the human rights in the way that we already have. So thank you very much. Thanks to all the panelists. Thanks to the people that was here during this event virtually. I hope that much more people will follow this discussion in the future and after watching this great event. My frustration for not having you here in person in the university, but as I said at the very beginning, Mother Nature is still today, much more powerful than AI, neurotechnologies, new technologies, or whatever. So it was impossible to have you here. The university decision to close the law school was, we received the news yesterday. at the evening, so we need to change dramatically and quickly. But I'm very, very glad that you were very flexible to say that you are in. So it was a great panel. And last but not least, thanks for the students who has been working hard almost from 1 year in organizing all of this, contacting you, trying to build on the program. Jordan, Kathleen, Austin, Federico, Dean Fellows of the Center, Carson from the Technology Security and Security, Cybersecurity or whatever Society here at the law school. My colleagues from the NIS, from the conference and events session, Ryan from the technical support. So there was a lot of people that allows us to convert an in-person meeting, a real meeting, in a virtual meeting in almost one night. So thank you to everybody, and I hope to have a new event probably next semester, and I hope not to do it Denise is saying Mark and Ryan. Yes, I mentioned Ryan only, Mark also, all the people that has been working with us. And I was saying, I hope to have a new event on this. I'm sure that I am going to organize the event during the hurricane, season, just to, try to fight against Mother Nature. No, sincerely, thank you very much. A safe trip, or stay safe. And I hope to continue this conversation with all of you soon. So thank you very much. We'll stop here. Thank you.
Thank you. I learned a lot.
Bye bye.